Getting started.
Okay, I'll get my gavel out, make it official. And good afternoon. I'm going to go ahead and call this session of the City of Issaquah Hearing Examiner to order. For the record, today is April 18th, 2022, just after 1 p.m. We have one item on the agenda today. This is number COD 19-00108, and it is an appeal of a notice of violation that the City of Issaquah issued back on January 11th, 2022, related to unpermitted demolition and construction work at 5126 Northwest Sammamish Road that was later appealed by the property owner, Robert Heyer. And that is what brings us here today. So I am Andrew Reeves. I serve as the hearing examiner for the City of Issaquah, and I'm tasked with holding certain hearings like this. And today it will be my role to collect evidence in the form of exhibits and testimony to determine whether, in this instance, the appeal should be denied, upheld, or the NOV should be modified in some way. So that's ultimately what I am going to be doing. All testimony today will be under oath or affirmation. That's because were there to be any appeal of my decision to the Superior Court, the recording of today's hearing, along with the admitted exhibits, and my decision would serve as the foundation for any such appeal. It's a little bit more of an informal process than court itself, but there is a sort of an order that we'll try to follow. And to begin with, I'll just have the two sort of sides introduce themselves. So, Attorney Soto, if you could introduce yourself on behalf of the city.
Yes, I'm Anne Marie Soto, Deputy City Attorney for the City of Issaquah. And with me today are the city's representatives, the building official, James Gray, and also Code Enforcement Officer, Lori Dunning.
Great, thank you for being here. And then we have our appellant, Mr. Hare. Thank you for being here.
No, thank you. I'm Robert Heyer. I'm the property owner and the
Okay.
one who calls. Yeah.
So in advance of the hearing, my office had issued a pre-hearing order that sort of tried to lay out a process to ensure we weren't totally chaotic today. And the parties did a good job following the requirements of that order. There weren't any what we would call dispositive motions or motions to sort of try to dismiss or take care of matters in advance of the hearing. So that was a non-issue. And then the parties each submitted exhibits in advance of the hearing. My records show that the city offered exhibits C1 through C18. Ms. Soto, is that what you intended on including?
That is accurate, yes.
Okay, and then Mr. Hare, I had A1 through A6. Is that what you had intended on including?
Yes, sir.
Okay, so Mr. Hare, did you have an opportunity to look at C1 through C18 in advance of the hearing?
I looked at some of it. I don't remember reading 18 different files, but that's okay.
A lot of it was photos, to be honest. So some of them were just a page. But my question for you, I know you're not an attorney, but I got to sort of treat everybody the same.
Yeah.
But the question is whether you have any objection to those exhibits. And if not, I'm going to treat them as included into the record.
Yeah, that's fine.
Okay. And then, Ms. Soto, any objection to A1 through A6?
No.
Okay, so no objections to the exhibits, and I note both parties did provide, we'll call them pre-hearing briefs in advance, sort of stating their position, and I did review those as well. So first off, Ms. Soto, any procedural issues or anything you wanted to address at this point before we really dive in?
Yes, just one preliminary matter. In reviewing Mr. Heyer's pre-hearing brief and in looking at the city's brief as well, it doesn't appear there's a dispute as to whether or not there's a violation. And so it's really a question of what the appropriate remedy would be. So I can go through all of the foundation questions to establish that the violations exist, but if Mr. Heyer agrees that the violation as far as constructing or demolishing the garage without a permit, constructing the new storage container structure without permits, and the fact that the structure is over the setbacks, and I think there's potentially a dispute about whether or not the height of the structure is okay. That's something that we might still want to go over. But if we can, and that the structure is over the property line, but if we can just agree that the structure, the original garage was demolished without a permit, the new container structure was constructed without a permit, and that the structure is currently located over the setbacks and the property line, then we could probably skip all of those foundation questions and then just move forward with what the appropriate remedy would be and whether the structure as proposed would be allowed to exist on the property. That would probably save all of us a lot of time, but I understand that Mr. Heyer would likely want to weigh on as to whether he would agree to that approach.
Absolutely.
Yeah.
So I had a similar thought, and so I wanted to ask Mr. Heyer, the sort of brief, as it were, essentially said, I acknowledge, there were other circumstances, COVID, all kinds of things that led to issues with obtaining necessary permits. But do you dispute that demolition occurred and then the structure was built or constructed on the property without you having obtained permits? Is that all?
No, I don't. You're right. I don't dispute that, and that was my error and my mistake from the onset. Obviously, quite honestly, but the one thing I do want to be clear about, though, it was never my intention to demolish the garage, entirely. Hence, the idea was to remodel it and use the existing foundation, the exterior walls, and then create a structural member to do what in my mind, this is probably leading into, I just want to make sure by saying, I do agree. I obviously made these mistakes. I went about trying to remedy them. It took me time and process and some conflicts, obviously, with my neighbor and other things that have just exacerbated all those things. And it just got out of hand. But that being said, I I I, I want to remedy it if we can, and I want to finish my garage. And I guess the one thing I keep hearing is structure too. Like, I wasn't aware, and of course that was part of it, if I would have gone the proper route, that I wasn't allowed to have I didn't want to build a living space. I wanted to put an office above my garage, and now I've gone all the way down this whole route of actually building a ADU and to try to adhere to permitting. That was my remedy. Of course, I don't know if that's happening, or if I've caused more problems by trying to do that.
So real quick,
Yeah,
I didn't swear in Anne Marie Soto because she's an attorney, and so she's just sort of making arguments as opposed to giving me a factual analysis of the situation. Quite a bit of what you just said was sort of factual in nature. So what I'm going to do is swear you in. Do you swear or affirm that everything you just testified to or just said and everything you plan on saying is truthful to the best of your ability, Mr. Hare?
I do. I
Great,
do.
thank you. I just want to make sure we have that taken
Yeah.
care of. You're in a
No.
weird spot because you're going to be wearing two hats. You're going to sort of be
Yeah.
but
Yeah.
so what it sounds like then is you're not in dispute over the facts. I know there is, based on the evidence in your exhibits, you're sounds like trying to work with the neighbor in terms of potentially an easement, and we could talk about that in a second. But let me go back to Ms. Soto just for a minute. So it sounds, this is a question I had for you to begin with, was in a traditional notice of violation or NOV hearing, it's the city's burden. Here, we don't really have that problem because Mr. Hayer has acknowledged that, the work occurred and, the why it happened, we can talk about. But this has also been framed as a sort of building permit interpretation appeal, which is a little different. So could you walk me through, in your mind, what would my role ultimately be here today? You did sort of say in the brief, that the city would seek to essentially have me dismiss the appeal and come up with, some dates as to when compliance would have to occur.
Mhm.
There was no reference to fines being sought. Obviously, that's possible under the code. But could you just sort of walk me through what your thought process today is, Ms. Soto, based on what you've heard and kind of what you've thought about thus far?
Yes, so as I mentioned already, I think at this point, really, all we're looking at is what the appropriate remedy is. And per the city's municipal code, the hearing examiner's authority isn't to stand in the shoes of the building official and to determine what can and should be allowed on that site. Rather, the hearing examiner's role is to determine whether the city made an error in issuing that notice. And if there is a dispute about the process that the city used, or if the city used the wrong code, things like that. So what we would be seeking today is simply what you just said, a determination from the hearing examiner as to what the appropriate remedy would be, whether, that is that Mr. Heyer can reapply for the building permit, or whether he needs to simply move forward with what the city is asking, that he go ahead and demolish the structure that's currently there by obtaining the appropriate permits to do so. Like I mentioned, there was the demolition of the original garage and the construction of the new garage. The city wouldn't be requiring two separate permits. That would be one permit that would then include a final inspection. At this time, the city is not seeking penalties, so that wouldn't be part of the factor. But we would be asking that if Mr. Heyer doesn't comply, if the examiner finds in favor of the city and determines that he needs to remove the structure, that the hearing examiner put in some specific dates as to compliance, and that if Mr. Heyer doesn't comply by those dates, that a penalty would begin to accrue.
Okay. And so the one thing I'm trying to think through is if Mr. Heyer is of the opinion that he wants to try to get a permit, you know, is there factual information I should be learning today from your witnesses to help me determine if that's an appropriate remedy or not? I'm trying to, I understand the idea of, we think the appropriate next steps are require, I guess one thought is either require that a permit be obtained by a date certain or removal. I mean, I know a permit's required for either. I guess what I'm trying to say is some kind of permit allowing the structure be obtained by a date certain, or alternatively, the demo permit and
Mhm.
inspection by the same date, something to that effect. But if the city's of the opinion there's just no way the structure would be allowed, is that something I should be looking at right now? I mean, your
I
thoughts
think
on
there,
that?
yeah, I think there is testimony that the building official can provide for the hearing examiner to consider that will help you to understand that the structures proposed would not be permitted in the city of Issaquah.
Okay.
There are too many issues with the location of the structure that are separate from the fact that there was no permit obtained at all. And so I don't know if that would be helpful to the hearing examiner, but I believe that by hearing that testimony, that may help the examiner determine that the appropriate remedy would be demolition of the structure in totality.
Sure. Sure. And I think ultimately the goal, one way or the other, is clear guidance for everybody as to what happens next. So with that, I think it probably would be, again, I don't think there's any question of permits were necessary. I think everyone agrees on that. But testimony on, this is, there's the setback issue, potentially the height issue, some other things. I think it would be helpful to get some information from the building official in particular, and that will help me essentially be able to think through the appropriate remedy. And just to be clear, Mr. Ayer, sorry, is it Hire or Hayer? I don't want to mispronounce your name.
It's higher. Yeah, like Meyer with
Okay.
an H. Yeah.
So what we're gonna do is I'm gonna ultimately right now I'm gonna swear in the building official. Ms. Soto is gonna ask some questions of the building official. Then you will have an opportunity to what we call cross-examine or ask questions that are sort of in the same approach of the building official, and that'll be the next step. And then after we've heard from the building official and code enforcement, if Ms. Soto thinks it would be appropriate to call on code enforcement, then we'll hear from you and you can testify. And then I'll try to work through in my head best steps after that. Okay?
Okay.
Does that make sense? Okay, so with that, then why don't we swear in James Gray? And thank you for being here. Do you swear or affirm to tell the truth in the testimony you give here today?
I do.
Thank you. And could you just clearly spell your name for the audio and explain your role here at the city?
James Gray, Jamesgray. I'm the building official for the city of Issaquah.
Okay, thank you. And Ms. Soto, go right ahead.
All right, thank you, James. I'm going to go through a list of questions. Bear with me. I had an outline that was going to go in a completely different direction, but so I might need a couple of pauses. All right, so how long have you held your position as a building official for the city of Issaquah?
Building official about 2.5 years.
And prior to that time, were you a building official elsewhere?
I was a deputy building official with the municipality of Anchorage for some time and fire marshal.
Okay. And how long have you been in a role where you were a building official or interpreting building codes?
So about 28 years in what I call code enforcement.
Okay. All right. And have you reviewed the file and all of the exhibits in this case, including the exhibits that were submitted by Mr. Heyer?
I have.
Okay. So as we already discussed, there's no dispute as to the existence of the violations here. So really, I'm going to be focusing my questions on issues such as the setbacks and the height of the structure. Can you explain to me what the concern is regarding the setbacks?
Sure. So there's a couple of things with setbacks. There's a land use provision and a building code provision. So the land use provision is addressed in Title 18, and it has to do with it just has to do with how close you are to the property line for multiple reasons that are not building related. The building code provisions to the setback have to do with fire and life safety. So if I have a building on my property that is up against the property line and that structure burns and it is within 5 feet of your legal structure that's on your property, I could potentially impinge your structure. It also has to do with fire department access between those structures. They need a certain amount of distance to run hose lines or get equipment between there. And then it also has to do with the openings that are in each structure with how close they are to the property line. Typically, you cannot build on the property line with any openings in the structure at all in the building code.
Okay, and so you mentioned that there are two concerns, both on the building and on the land use side. And so primarily as the building official, you're looking at these types of issues from the building side, correct?
That is correct.
And you're not a planner, is that correct?
Correct.
But are you familiar with the city's land use provisions as they relate to structures such as this?
Correct. For this provision, yes.
Okay. So the original garage was also located within the setbacks and over the property line. Is that correct?
It looks like it, although I have not seen a registered land survey yet. From the King County maps and the photos, it appears to be over the property line.
Okay. And although that structure was almost completely demolished, it appears that 2 of the walls remained, correct?
Correct.
Does that change your opinion about whether or not this new structure would be allowed in that same location?
It does not.
And why is that?
Because a non-conforming right is a right under the land use code. There's an existing buildings code that applies to the building provisions. And when you remove this substantial portion of the structure or demolish a substantial portion of the structure, then you don't have any ability to rebuild that thing in that particular place.
Thank you. All right. I now want to turn to the proposed use of the structure. So within the original building permit plans, what was the proposed structure intended to be used for?
Originally, I think it was storage and garage. I think that's originally what he proposed.
And is there a height limitation for storage and garage only structures?
In the land use code, yes, they can be in this particular zone for this use only 1 story for storage garage.
Okay. And in Mr. Heyer's pre-hearing brief, he notes that he became aware, I'm not trying to characterize this testimony, but in his pre-hearing brief, he discusses that he became aware that there was a concern about the height, so he later determined that maybe an accessory dwelling unit might be allowed on the site. Is that your understanding?
Correct.
Okay. And is there a height limitation for accessory dwelling units within this zone?
Not under the building code. I think under the land use code, there's a 30 feet without trying to get exceptions.
Okay. In your opinion, does changing the use from a storage structure only, garage and storage structure only, to a garage with an accessory dwelling unit on top of it change your opinion as to whether or not this structure would be allowed to remain in the place that it is on the property?
No,
And why is that?
because the provision, the proximity to the property line, again, it's a fire life safety provision. So that it's got occupied space in it, whether or not it's an office or a bedroom or a living room, probably makes it even more hazardous to have it over the property line. A storage unit is not typically, it wouldn't even typically be a place where there'd be a fire. But fire is only one of the perils we'd be worried about. But the provision with relation to the property line doesn't differentiate between those two.
Okay. Now, looking at the issue of this structure being over the property line, is it your understanding that Mr. Heyer has permission to be over the property line?
It is not.
Okay. And would that, if he were to obtain permission from the neighbor to encroach onto their property, would that be something that would be allowed by the city to enable the structure to remain where it is?
It would not.
And why is that?
There would be a land use process that would need to take place before that could happen. So probably a lot line adjustment. That process takes some time. And then we would need a new property line boundary survey done so we could see where this thing sits. And I still don't know if I don't know how much land we'd be talking about, if it's far enough. If it's a foot over the property line, you might need 6 feet of the neighbor's property. I just don't have enough information to know that.
So an easement from the neighboring property owner that just goes right up to the edge of the structure, that would not solve the concerns that you have from a building or land use perspective. Is that correct?
That is correct. It would not solve it.
So just to kind of recap, if the structure was for storage and garage purposes only, it would not be allowed because of the setback location and the height restrictions. Is that accurate?
The number of stories, but the number of stories does get back to height restriction. That is accurate.
And the setbacks and location over the property line?
Correct.
Okay. If the structure is being used as a garage or storage on the first level and an ADU on the top level, again, would this structure be allowed where it currently sits on the property?
No.
Does an ADU require plumbing work?
Yes.
Do you know if the original building permit application included plumbing work as part of the project?
I believe so. I can look quickly.
Yeah, let's pull up the. So if you can take a look at Exhibit C17 that was submitted with the city's exhibits.
Okay.
Looking at page 2 of that document,
Okay. Yep.
does it make a mention of plumbing work being included with this project?
I see a bathroom. There's the toilet and sink and shower. The kitchen. All those things require plumbing.
But on Exhibit C17, do you see any mention of plumbing work being included?
Apologies, I'm looking at the plans that were submitted. C17.
Sometimes it's easier being all on a video meeting, but sometimes it's a little more difficult because I could have just handed you a document if we were in person. So I apologize about that.
Well, I have multiple documents open. I wanted to have everything I needed, so I guess I don't have it. Of that specific one, C17.
And to clarify, see, this is an application, not a set of project plans, correct?
Correct.
Minnesota, that's what you're trying to, so this is
Yes.
the sort of garage remodel application, I believe dated, oh, was it? Oh, sorry, hard to find the date.
June 22nd, 2020.
There you go, thank you.
C17.
June, yep, 2020, okay.
Yeah, there were so many subsequent to that, so that one I'm sure doesn't. So I think she's trying to get him to say there was no plumbing in there.
And you'll have a chance, Mr. Hires.
Oh, sorry.
That's
Sorry.
okay.
I may need you to resend me the attachments.
James, I forwarded a OneDrive file of all the exhibits in an email shortly before this meeting, if it's easier to access. Exhibit C7
Okay.
that way.
Got it. C17. My apologies.
That's okay.
So C17 is the permit application, page 2. Okay.
And does that document, my question was whether that document reflects that there was going to be any plumbing work done for this as part of this application?
It does not.
Okay.
Like it says no mechanical and no plumbing work. So,
Because
Which
it was
would
going to
be-
be an office.
And you'll have an opportunity, I promise.
Sorry, I apologize.
Okay, so those would be things that would be required for an ADU, correct?
correct.
From your perspective as the building official, what is the goal with this code enforcement matter?
What was the goal is, pardon me?
What is the goal now?
I think the goal now is to get the structure removed. Since it was illegally constructed and the demo was illegally done, it looks like it doesn't work on this lot in this location. And I think the goal would be to get it all removed.
Okay. I have nothing further for Mr. Gray.
Okay, I have a couple quick questions, then I'm going to pass it to you, Mr. Heyer, after my questions. So, as the building official, well, first off, you pointed out at the outset that there's certain requirements you described as the land use requirements, and those would be the council has decided, 5 feet or 10 feet. There are certain setbacks that have been decided by the council in various zones. So that's one aspect. But the aspect you're most concerned with is the life safety, structural integrity, fire. That's what your expertise is in, correct?
Correct.
So my question is, for something like a project like this, an applicant can seek a variance from the zoning requirements. Is there any process to seek a variance from these, building requirement, fire safety requirements that you're aware of?
There is not. There are provisions in the code to get a little closer to the property line if your building's sprinkled or if it doesn't have openings, but there is no provision to get over the property line.
Okay. So there's no sort of variance process that would address this situation in your mind?
There's not.
Okay. Um, and then Ms. Soto had asked about if an easement seems like a weird word to use, but if permission of some kind or was granted by the neighboring property owner, and we have a sort of draft in the appellant's exhibits, nothing that's been signed. But that doesn't essentially solve the problem because if you just move the lot line so that this structure's within Mr. Heyer's lot, you still have that same concern you earlier expressed about the fire code provisions and setback requirements that are not zoning related. Is that right?
Well, if I understand your question correctly, no, I don't think it is right, because if you get a lot line adjustment, that basically it's also sometimes called a no build easement. So that means the neighbor would grant you rights and would be recorded that they could not build within that, let's say 5, 6, 7, 8 feet, whatever was needed. Then where you built the structure in the existing condition would be in a legal location because the lot line would be 6 feet away
Okay.
after the LLA happened.
So if Mr. Heyer's neighbors, essentially granted him that can, again, not just moving the lot itself so that this structure's on his lot, but then also agreed to 10 feet, 6 feet, whatever the no build. Um, that's sort of at a minimum to get you in the door. Uh, there's still other concerns about height, etc. But that would at least be the sort of bare minimum needed to even make it marginally feasible? I'm just trying to work through, what the situation is, right?
So it's a bit theoretical. So if we have a land surveyor that's signed by a registered land surveyor, I could give a more definitive answer. But let's say that the distance is 5 feet, say the land use distance is 5 feet, and we get a lot line moved so that 5 feet is 5 feet away from the property line, then that could work. And if it was an ADU, it could be 2 stories, so that could work. And the rest of it would just have to, we'd have to get the structure ironed out, which we don't have yet, the structural overturning and the openings in the building and the plumbing requirements and all of those other pieces. So it's a theoretical possibility.
Okay. And then a more practical, question, just in terms of, you've been doing this a while, in your mind, uh, if the route Mr. Hire decides to take is, I'll just remove the structure, what would be a reasonable time frame in your mind for that work to be done, if that's the decision I ultimately made, in terms of compliance? I mean, obviously one can't just, pick up and move it tomorrow. It's unlikely, but in your mind, what would be a reasonable time frame to seek compliance in terms of getting a demo permit and removing the structures?
I think 30 days, and these are, shipping containers, so they actually probably can be just picked up and put on a flatbed and pulled away. The 2 walls that are remaining, you probably push those over and put that in I don't know, but from the photos I've seen, it looks like that'd be pretty easy, but I think 30 days would be reasonable.
Okay, great. Thank you. Those were the questions that I had for you. At this point, I'm going to turn to Mr. Hire. Mr. Hire, this is your opportunity to, again, cross-examine or ask questions of this witness. You'll have an opportunity to give your own testimony later, but this is, if you had any clarifying questions you wanted to ask Mr. Gray, this would be your opportunity.
No, I get, well, I don't know, but I guess I don't, because I mean, I know this is all coming down to, so maybe you want me to save that for a statement, but honestly, this whole idea of the property line, that my only intent in the brief was to show that when I purchased this house, there were encroachments. No,
I'm-
okay, so, all right.
I'm definitely going to hear your statement later,
Yeah.
but I'm going to try to follow this order. Did you have specific questions for Mr. Gray to clarify what you
I guess maybe one, because I kind of hear him bringing up something. So, Mr. Gray, just because I lack the knowledge about what a remodel. I was advised by leaving the existing 18-inch foundation and the 2 exterior walls that I could go about remodeling my garage. I didn't get a permit to do that. It took place. So right now, if I was coming to the city and saying, I've got a bad roof, I've got a bad garage door opening, I'm going to keep the existing structure on the existing slab, I want to remodel, would you allow me to do that? That's my question.
Sure, I think I'd like to see, I'd want to see your site plan, and if it indeed was over the property line, I'd tell you no, you couldn't do it. If you take any of it apart, it's over.
But you would allow me to leave my existing garage, even though no one ever questioned where it was sitting, and I didn't either until I did the survey. But my neighbor never said, you got to demolish your garage because you're in my yard or blah, blah, blah. But you wouldn't have done anything until I asked you to do something. And you would have told me I could not remodel my garage.
That's correct.
Okay. So I'll tell you right now, Your Honor, that was the biggest mistake. But
And
for me, that's my mistake.
I can tell you're frustrated, and we will.
Yeah.
You'll have an opportunity, But Ms. Soto, based on what you've heard, did you have any redirect for this witness before we move on?
Just one quick question. Mr. Gray, do you know what the violation penalty is sorry, let me rephrase that. Do you know what the penalty is for violations of the building code?
Depends on the penalty, depends on the violation, I guess. So we'll do a stop work order, and I need to see a specific, so there's a couple of things. So building a structure without a permit, there are fines for that. Occupying a structure without a certificate of occupancy, I think there's a $1,000 a day fine and criminal penalties. But building without a permit, I'd have to take permit.
Hold on one
Say
sec.
something?
You'll have an opportunity later, I promise. And Ms. Soto, to be clear, again, you said at the outset, the city is not currently seeking any fines. It's more of if I were to set a date by which something needed to happen, then the potential for fines would begin after that point. Is that the idea here?
Yes, really, it's more for Mr. Heyer to understand what the potential penalties could be. But as I did mention, at this time, and per the city's notice of violation, the city is not seeking any penalty.
So that code section is 1604, 110, 114.4 violation penalties. And that's anyone who fails to comply with any of the requirements thereof, who erects, constructs, alters, or repairs a building or structure in violation of the approved construction documents or directive of the building official or of a permit or certificate issued under the code shall be guilty of a misdemeanor, and upon conviction thereof shall be punished by a fine of not more than $1,000 or by imprisonment not to exceed 90 days, or both such fine and imprisonment every day or portion thereof during which the violation occurs, continues, shall constitute a separate offense.
Okay, and just one final question, and just to confirm, the city's ultimate goal here is compliance, not to seek penalties or jail time for Mr. Heyer. Is that correct?
Correct.
That's all I have.
Okay. Thank you. And did you intend on calling Lori Dunning?
Not at this time.
Okay. So at this point then, Mr. Heyer, sorry, this would be your opportunity to testify. I know it's sort of challenging in terms of the argument and the testimony. I'm just going to let you say what you want to say, and I'll sort out myself what is argument versus factual testimony. Does that make sense?
Yeah.
Okay.
I appreciate that.
And then after you testify, Ms. Soto will have an opportunity to sort of cross-examine you in terms of asking questions because you're serving as a witness. Does that? Okay.
Yeah,
Making
that's
sure you
fine.
understand the process. So please, the way I would say is if you want to try to do the fact testimony part of it now, and then do the argument after, that would be
Okay.
ideal, but it is what it is.
Yeah. The only thing I was trying to, I remember I raised my hand just because I actually paid a couple, they were just fines, and I couldn't even tell you exactly what they were, but they were, they were issued to me, and I paid them to the court. And so, it's not consequential or it doesn't mean anything, but I just wanted to just share that I was trying to, continue the process, and because I was going so slow, I had to pay some fines and stuff. So, but like I said, that's not really important in the big picture. So, so I guess all I wanted to say, and I appreciate, and that's why James actually already answered my question, which again, so the issue is I have a garage on a property I bought, back in 1997, and the garage is 50 plus years old, and it's been sitting there. And when I bought the house, there were no easements on the east side of the lot. It was only on the west side. I have a neighbor who's got a driveway that goes through my yard and a pier that was in my lot line. So there was no issues with that lot. And that's, in my briefing, I tried to just explain that in layman's terms. But as you can imagine, until I did the survey, I was the one who had the survey done. I became aware of everything, but my neighbor didn't care that my garage was sitting where it was sitting because, like I said, it was there. It's been there for 50 years, and that wasn't an issue. I made the mistake now, and here we're sitting here. You can do whatever you want with me, but I can tell you this: I did not want to remove my garage. I mean, there's only one place for a garage on that lot, and my driveway. If you look the way it is and everything, the slab is there. I even had the slab tested. It's 18 inches deep. It's bigger than anything you get nowadays because we pour such poor concrete slabs. But the existing, and hence why I kept up the exterior walls, because I need that garage. I want that garage. If I can't put a second floor on it, I understand. My mistake. I'll figure out how to get it all disassembled and taken down. But I'm gonna finish. I would ask that I be able to have my garage until my neighbor. I'm gonna deal with him anyways because he never came to me and asked me to do anything until I decided to start remodeling my garage. And so I've got that issue, and that's not your problem. Of course, that's my problem with my neighbor. And then, like James said, I've got a lot line issue that I was aware of, and I'm trying to figure out how to do that because at some point I'd like to remodel my house, but I don't want to. I would like to have my garage, and if I'm forced to take everything off, I have a concrete slab. I mean, I could tell you, I'll probably end up just parking my cars on the concrete slab without any walls. Or, I mean, I'm not, I'm not sure what the city wants me to do, and yeah, that's my long rambling statement. Yeah.
Sure, and Ms. Soto can correct me if I'm wrong about what the law in Issaquah is, but essentially, I understand you're frustrated, but this is not just the city of Issaquah, but when you have a non-conforming structure, a sort of pre-existing situation, that situation is usually allowed to continue indefinitely until something significant happens to change the situation, such as a remodel. And I get why you're frustrated because why would a normal person know that? So I understand the frustration. I'm just trying to explain sort of the bigger picture on the law and in various jurisdictions. The details are different in minor respects, but essentially you got to keep the non-conforming nature of something until a major change occurs, and then the goal is you're always trying to bring things up to code, as it were. So Ms. Soto, did I misspeak there? I'm not trying to give legal advice. I'm just trying to explain the bigger picture.
Yes, that's accurate.
Okay.
Yeah, the city would have no reason to go out and just find non-conforming issues within the city. It's only when you're alerted to a change that it would potentially trigger bringing it up to code.
Yeah, and so, sorry, first off, Ms. Soto, did you have sort of cross-examination questions for Mr. Heyer that you wanted to ask?
I just have a couple of quick questions. The first question is, do you currently have permission from the neighboring property owners to encroach onto their property?
Is there any kind of agreement to? No.
And do you have permission from the neighboring property owners to apply for a boundary line adjustment?
That I'm not aware that I'm able to do that unless he and I agree to do a boundary line adjustment. So does that answer the question?
Somewhat.
I
I'm
was
just
told-
asking, do you have an agreement with him to apply for a boundary line adjustment? How about that?
No, we're not doing that. I'm asking him for an easement, though I provided that. So
Okay. And do you have any reason to believe that your neighbors would agree to a boundary line adjustment?
yes. Oh, and not a boundary line adjustment, but an easement. He's in principle agreed to. But again, he hasn't signed anything, so that doesn't mean anything until, as you know, you see something signed.
But not a boundary
And
line adjustment.
no, could I add a little bit of just color to that, just only because I had to get some advice about this? Just this might help. So regard this whole thing with the boundary line, like I said, I became aware of it. I didn't know what to do. An attorney advised me how long you've been there, blah, blah, blah. And he basically just said, listen, that garage has been there 50 plus years. You basically own that land. That's yours. And they call it adverse possession. I just said, oh, no, this sounds like a legal thing. I don't want to do this. You know, it's going to take time. I can get your attorney's fees paid for. These are property guys now. There's attorneys that just prey on this kind of stuff, probably. But that being said, I went to my neighbor and I just said, I don't want to do this. So can we just agree to an easement or something where I don't build on it? It's your land. I'm not going to do anything else, but I want to keep my garage where it is. And in principle, he understands that. He doesn't like me bringing up the adverse possession thing, but it's a reality. If after I get this thing settled with you guys, if I just have a concrete slab and a wall or whatever the judge decides, I've got to deal with it because his yard is above a rockery, and it was built that way when they built their house, and they thought the property line was where it is. So anyways, no, we don't have an agreement.
I don't have anything further.
Okay. So certainly some things for me to think about in terms of, sensible next steps, what seems possible, etc. So my plan is to take into consideration the exhibits that are included in the record, the testimony I heard today, along with the arguments that both sides have made. And I will produce a decision here in the next couple of weeks. And then my decision will very clearly as I can do it, try to delineate required next steps one way or the other, so that everyone is on the same page as to what needs to happen next, so that there's no confusion one way or the other, and everyone can move on one way or the other. So that is my plan. And so I will, like I said, here in the next couple of weeks, issue a decision/order related to this appeal, and Ms. Barrell, ensure that you receive a copy of that once it's produced, and we'll go from there. So thank you to everybody for being available to participate. Thank you for those that did participate to answer my questions and the questions of others. And with that, I think we can conclude today's hearing, and one way or the other, we'll get, a straightforward guidance so that everyone can move on. So with that, thank you, everybody.
Thank you.
I appreciate it. Thank you, everyone.
Thank you.